Welcome to This Explainer. Today, we are tackling what is arguably the most massive threat to East African legal practice right now, AI hallucinations. We're talking about the very real, very terrifying danger of artificial intelligence confidently inventing legal precedent completely out of thin air. We'll cover exactly what you must do to stop these fakes dead in their tracks, including how dedicated platforms like Katiba Lex are doing the heavy compliance lifting for you.
Look, if you aren't incredibly careful, popular AI tools will fabricate cases, literal ghost citations, that look and sound perfectly real. They'll invent parties, assign fake case numbers, and even write convincing yet completely fictitious judgments. Presenting one of these in court isn't just an embarrassing slip-up, right? It puts your entire professional integrity and your client's case at massive risk.
So here is our compliance briefing for today. We'll cover 1. AI risks to legal precedent. 2. Core rules of citation. 3. The East Africa timelines. 4. Jurisdiction-specific red flags. 5. The 10 basic verification facts. And finally, 6. Using the master prompts.
All right, Section 1. AI risks to legal precedent. Let's look at the foundational stakes here.
Now, you already know the doctrine of precedent, stare decisis. It's the absolute bedrock of our common law system. Lower courts are bound to follow the decisions of the courts above them. You adhere to decisions, and you don't disturb questions that have been put to rest.
And that is exactly why AI hallucinations aren't just minor software bugs. They are an existential threat to this entire system. When an AI fabricates a case, it completely corrupts the certainty we rely on to predict litigation outcomes. It distorts a judge's obligation to impartiality because they're suddenly forced to consider fake constraints. Ultimately, false precedents literally pollute the development of our regional jurisprudence.
Moving on to Section 2, Core Rules of Citation. This is all about spotting the fakes.
You know the hierarchy of legal authority across the region? Supreme Court at the top, down through the Court of Appeal, High Court, and Magistrates' Courts. But why does this matter for AI? Well, because AI notoriously jumps tiers. If an AI places an employment dispute at the Supreme Court in the first instance, completely skipping the Employment and Labor Relations Court, that is a massive glowing red flag.
Here's an immediate, highly actionable test you can use. Every real case generally has two components: a neutral citation tracking the court and case number, followed by the report citation, like an EKLR year. If an AI gives you only the report citation, say just bracket 2023, close bracket EKLR, without a formal neutral citation attached, it is highly likely to be an unverified ghost case. The AI knows the basic format of a reporter, but it really struggles to consistently generate those complex internal tracking numbers.
Which brings us to Section 3, the East Africa timelines. This is your historical verification toolkit.
These dates aren't just legal history trivia. They are the exact facts that expose a hallucination. Take a look at this timeline for Kenya. The official digital platform, EKLR, only launched post-2001. Before that, you had KLR, and earlier, the East Africa Law Reports. So what does this mean? If an AI hands you an EKLR citation for a case from 1968 or a ULII citation for a 2004 decision in Uganda, you immediately know it's completely fabricated. Those platforms literally did not exist back then.
And right here is perhaps the biggest trap for the AI. 2011. That year is a massive tripwire in Kenya. This is the year the Supreme Court, the Employment and Labor Relations Court, and the Environment and Land Court were all established. Any citation from an AI placing a decision in the Supreme Court or the ELRC before 2011 is completely 100% fake. No exceptions.
Okay, Section 4, Jurisdiction-Specific Red Flags. Let's look at a few more tripwires.
For Kenyan practice, definitely remember our post-2001 rule for EKLR. But here's another huge one. Magistrates' courts are almost never reported on the EKLR online platform. So if your AI cites a chief magistrate's court case and slaps an EKLR tag on the end of it, yeah, that is 99% likely to be fake.
Meanwhile, over in Uganda, the official online source is ULII. The absolute timeline rule there, post-2009. Anything before 2009 should be in the Uganda law reports or the EA law reports. So an AI gives you a 2003 ULII citation? Absolute hallucination, rejected on site.
And for Tanzania, the official online platform Tanzali only exists post-2011. A 2005 Tanzania citation is guaranteed fake. Also, Tanzania has distinct systems, right? You have to always verify if the citation explicitly specifies whether it applies to mainland Tanzania or Zanzibar. If the AI is vague about that, do not trust it.
Moving on to Section 5, the 10 basic verification facts.
This field reference table reveals some critical truths about legal reporting. For example, fact number 2, the EKLR reporting year is often completely different from the actual judgment year. An AI might confidently claim it found a recent 2023 case because it sees 2023 in the EKLR bracket. But actually, scratch that. If you pull up the PDF, the judgment itself could have been decided back in 2018. Always check the PDF date.
Also, keep an eye out for behavioral red flags when reviewing output. AI models love using informal party names, like just writing KCB instead of the formal Kenya Commercial Bank Limited. They'll invent impossibly fast timelines, like an ELRC decision and a Supreme Court appeal resolving in the exact same year. And crucially, AI often completely fails to distinguish between a binding ratio and passing comments, improperly serving up non-binding obiter dicta as what the court held.
Finally, Section 6, using the master prompts. Now that we know the rules, how do we actually force AI to obey them? We use master prompts, and by the way, these are the exact engines powering the KatibaLex platform.
This is what it looks like. This master prompt spans Kenya, Uganda, and Tanzania in one go. It sets incredibly strict system roles, explicitly forbidding the AI from mixing jurisdictions. No more Supreme Court of Kenya cases magically appearing on a Uganda ULLI link. Most importantly, it enforces a mandatory output format requiring the neutral citation, the court, and flagging any verification concerns up front. And this strict architecture, it's natively built right into the KatibaLex AI environment.
Now you can easily deploy this toolkit yourself. Option A, just copy and paste this prompt text as your very first message to the AI. Option B, set it as a permanent standing instruction in a custom GPT or Claude project. But honestly, the ultimate completely frictionless deployment is option C. Simply head over to chat.katibaLex.com. KatibaLex already has the entire EA Legal AI Compliance Master Prompt Pack integrated out of the box, meaning it strictly adheres to all EKLR, ULI, and Tanzania historical reporting timelines for you.
But, and this is absolutely crucial, here's the most important takeaway. While these prompts and platforms like KatibaLex rigorously fence the AI in and force it to respect East African reporting rules, they aren't magic. They drastically reduce the risk, for sure, but they do not eliminate it. You must still physically verify every single case directly at official sources like kenyalaw.org, ulii.org, or tanzlia.org.
So what does this all mean? We end with a choice. Will you leave your legal arguments up to the imagination of a generic chatbot, or you secure your professional integrity? Stop fighting with AI hallucinations and start using AI securely by heading to KatibaLex.com today. And definitely join the KatibaLex Telegram channel to stay updated on the latest in legal tech compliance. The tools are right there waiting for you. Isn't it time to protect your practice?